So good afternoon, and thanks for joining me for our discussion on demystifying the emerging issues of AI in technology and law. My name is Myron Mallia-Dare, and I'm a corporate lawyer at Miller Thomson in Toronto. I have a significant experience supporting companies in the technology sector, and I advise on mergers and acquisitions, corporate finance, venture capital, and complex technology transactions relating to cutting-edge solutions such as artificial intelligence and cybersecurity. So I'd like to start off today just by asking how many people in the audience today either develop, commercialize, or utilize AI systems? Now, my next question, because I'm sure everyone who's listening today does, is how many of you have recently reviewed your agreements and documentation relating to these products or services? I'd imagine not too many, because it's not the most exciting thing you can do. But by not doing so, you may be putting yourself and your organization at significant risk. Today, we're going to be discussing some of these issues that will arise or could arise, and approaches to reduce this risk. So why don't we start out now with an overview of the current landscape of the AI and the law. AI, as we know, is rapidly developing, and the level of sophistication and autonomy of AI systems has progressed at an exponential rate. We imagine it will continue to do so, and this rapid innovation, coupled with development of AI systems across industries, means the risk and frequency of harm caused by AI systems will increase. Yet, the law hasn't kept up with these advances and applies concepts that aren't well suited to decisions made by an autonomous system. In addition, traditional technology agreements may not be suitable for solutions utilizing the technology that is AI, as they fail to adequately protect both the supplier and the customer from liability, or accurately reflect each party's ownership rights. So in that respect, who owns what in this process? What we're going to do is focus on today is some of the following issues, which we'll get into shortly, that are really emerging from the application of AI and will continue to be an issue as advances continue. We'll also look at approaches to limit this risk. So the first point we'll discuss today is ownership issues of improvements and the data utilized in using AI. What we're talking about here is the learning of and training of the AI system, and then any kind of advancements made based on the customizations requested by customers. The second point we'll look at today is liability issues, how the law applies and apportions liability to both the customer and the supplier, and methods to mitigate or apportion risk appropriately. The third, we'll look at privacy laws and data protection laws and see how these laws intersect with AI and some of the pitfalls and solutions maybe to navigate these pitfalls that can be addressed too as well. Now, in saying this, the typical issues, and I'll caveat this with this, is the typical issues that relate to technology contracting remain with AI systems. Organizations really need to be worried and concerned about protecting their own IP and owning what they've created. So contracting with suppliers, customers, employees is still absolutely critical. With AI, you just have these additional layers of concern. So as mentioned, we'll start off with some of the intellectual property issues relating to data inputs. Now, throughout this discussion, just for the ability to provide examples and to illustrate the points raised, we're going to use a bit of a fact pattern, a fictitious organization that in itself isn't that far away. So what we'll be talking about is a company, a fictional company called Autotruck Inc. Now, what Autotruck Inc. does, it's an autonomous trucking company that has developed B2B driverless tracking services for the transportation of commercial goods. So we'll lean on that example throughout. So addressing this first issue in use of data inputs. So the concern here is where do the inputs come from and who owns those inputs? Data is obviously critical for the ability of AI systems to function, and this data may come from many sources. If we turn to the auto trucks, driverless trucks, inputs could include data provided by its customers, data provided by auto trucking directly, data collected from various sources from its surroundings as the trucks operate, and then also third-party data from vendors. Now you can imagine that with all of these data sources, how can each one be utilized and to what extent it can? So when you're dealing with third-party ownership of data, there may be restrictions on how data can be used. The most common one is when dealing with customer data. In a traditional technology context, customers are very restrictive on how data can be used. Typically, customers will want to limit data's use to the services that are being provided to themselves and not used with their competitors. Now, this is particularly true for confidential information, in which proprietary knowledge is protected by the organization. Unfortunately, for AI, this doesn't really work. To be able to limit the use of the inputs to a discrete project for one customer does come with concerns. Yet that is the standard contracting provision of most customers. As you can imagine, how do you pass out the learnings from one customer to the next, and how do you carve that back from their AI system? Now, in that context, to limit this risk, AutoTruck should therefore understand what restrictions apply from all sources of data to how they use it, whether it be customer data, which looks to restrict to the purposes of that one project, or third-party data from third-party providers that may be for non-commercial purposes. All of these sources need to be reviewed and confirm that the terms of the agreement, whatever restrictions are placed on those terms and use of data, match up with the intent of the company. Failure to do so could lead to a breach of an agreement, which could lead to losses. On top of that, this could lead to a situation where the IP being created and the ownership to said IP could be at risk from a threat of a third-party claim. This is obviously detrimental to the business. So when you're thinking of that, the two approaches to avoid this is to enter into negotiations after finding out what restrictions exist, and then looking at alternatives to aggregate or anonymize the data is another approach, and see if you can work around those restrictions in that way. These are two very common tactics used here, but without doing that initial review, you may be offside agreements. So it's good practice. Linked to that are the IP issues relating to outputs and improvements themselves. Similarly, for these learned elements, it is critical to review the terms of the agreement to ensure that each party is aware of who will own all learned elements and improvements. A good way to characterize this, using the example from before, is in the context of AutoTruck's autonomous tracking services. If the AI solution learns from utilizing customer data and is able to increase efficiency, such as decreased transportation time through improved mapping, absent an agreement, that customer may have a claim of ownership to the improvement that was developed using their data, and in turn restrict AutoTruck's ability to commercialize that portion of the system. Now, practically speaking, if there has been an improvement to the AI system, the ability to roll it back may be of a concern or may be practically impossible to do. Thus, these things need to be addressed at the stage of contracting before they can't become issues. This issue, similar to learning, deals with improvements. So the customer pays for customizations or improvements to an AI system. Maybe it's the ability to, in the auto truck example, better navigate facilities in a more enclosed space. At the end of the day, the parties need to determine who owns that. And really, it's a discussion of who has the greater value of it versus the customer's ability to keep its competitive advantage over its other competitors. So the balance here needs to go into play when negotiating pricing and also the ability to negotiate the terms of the agreement. It's a very critical piece that needs to be addressed. And throughout this, one of the most vital suggestions here too is just ensuring you have advisors who can discuss with you and educate you on these nuances too, because as you can see in the examples we've discussed so far, these issues become a lot more significant after the fact, and you'll be in a worse position to be able to negotiate in your favor after the fact. So getting this done up front is absolutely critical. Okay, so now we're going to move on to the second point of the three today, which is the liability issues relating to damages or claims caused by AI systems where they've either gone wrong or been misused. So there's an overview. Canada's current legal framework, as with many jurisdictions throughout the world, is not well equipped to address the complexities of establishing liability for losses resulting from use or operation of AI systems. This is because these laws focus on who's at fault. As you can imagine, with AI systems becoming more autonomous, it will be difficult to determine if the AI system has malfunctioned and thus point to either the supplier, reseller, or third party who is at fault. In addition, as these AI systems become more complex in that they include numerous components that provide inputs, such as sensors, different kind of inputs of data, the root cause of the offending component will also become even more problematic, whether it be the failure of the AI system itself or the LiDAR or other sensor attached to it that is providing information. These tasks also, as AI systems become or focus on more repetitive tasks, the liability concern becomes ever greater. This is because this repetition of one single task, if it's done incorrectly, will just multiply the damages and that could arise from it due to the speed in which AI systems can perform. So that's kind of an overview of what's going on with the concerns here, but why don't we talk about some of those sources of liability? Now, one of the main areas is liability arising from negligent design of the AI system. This could be from a lack of time spent in the development stages or failure to provide ongoing testing or implementation testing, or failure to provide quality data. In the instance of quality data, you can get in a situation where bias may arise. So then essentially it's making the decisions, but based on poor inputs that it's received. Now, again, in the context of a repeatable tasks, this risk is greatly increased as well. So to avoid this risk, or at least to limit this risk, organizations should take steps to ensure that pre-commercializing the technology during those key critical development stages, they've ensured that adequate testing has been conducted on the AI system, and continuous testing is conducted to ensure that the AI system performs as required prior to commercialization. Having a strong go-to-market strategy is critical, but so is ensuring that the solution performs as expected. It's not just the legal issue here, it's the reputational issue, which could be detrimental to the business. So getting ahead of this prior to commercialization is critical. Now, the other area where liability commonly arises is in use of the system. Now, there are two pieces to this at-use discussion. It's liability arising from use in accordance with the terms of the AI system, how it's supposed to perform, or misuse by the customer. Now, in certain contexts, when you think of a car, if someone's driving it and their hands on the steering wheel, that's obviously, and an accident occurs, that's obviously a concern where misuse has happened. With an AI system, it's not as clear cut. So the big issue is in certain instances, the ability to determine who is at fault becomes a lot more complex and costly to litigate. So even if you're found to be not at fault at the end of the day, the expense in getting to that position can be significant. Now, an example of the use or misuse discussion in the context of auto truck, the example we used before, could be a situation where auto truck, its products and services were intended for highway operation, so not within the cities. In that instance, a customer of auto truck could direct the autonomous vehicle to drive through a city, or at least the suburbs of a city, and a catastrophic accident occurs. Now, in that instance, who's at fault? Now, it really comes down to, and you may think, well, obviously the customer is, but that may not be the case, because it really goes to whether this system was misused by the customer in this instance. So was there a defect is the other point here. Is the product malfunctioning? Or is there an issue with the ability to determine whether there was misuse here because there wasn't enough documentation provided to the customer? These are all the critical points here. So it's always advisable to avoid this liability to ensure that contracts and agreements and understandings between the supplier and the customer are crystal clear about how the product can be used. In addition, there should be limitations on who can use the product. Is there a level of required training? Is somebody more aware of it than others? These need to be distilled in writing for two reasons. One, to make sure everyone's on the same page, and also two, to make sure that if there is a question of liability, it's captured and encapsulated within that contract. It really is essential to provide customers with the parameters in which the solution can be utilized, and to what extent, if it's an AI system which produces outputs and results, such as in the financial services industry, when you're thinking of certain applications there, how much reliance can the customer have on those results? Really taking the time to do these steps will reduce your liability. So best practices when considering these points is to test the AI system during all development stages, provide continuous monitoring following deployment, provide clear limitations after the AI system has been commercialized to your customers, and really illustrate its intended use. Not only in the contract, but in your negotiations and discussions and documentation, including pamphlets and marketing materials, make it clear how it can be used and how it cannot be used to cover yourself from that issue. Contractually limiting or apportioning liability through contract is also another method where you can put in clauses which limit your liability and also include indemnification provisions in there too. As mentioned, it's very costly to litigate, so you don't want this going to court. The other thing too is ensure that you have adequate insurance to protect against issues, and also you're covered from liability, and that your policy does in fact cover the losses in which you can imagine happening. We don't want to be in a situation where you have the company litigation occurring and you're offside that, and It really impacts your ability to function as a business. And even if you're successful, it's very distracting. So it stops you focusing on those things that matter, which is the development side. Okay, so the final issue we'll address today is obligations under data protection and privacy laws. As previously discussed with AI systems, these systems utilize data from various sources. They also can process a significant volume of data in a quick fashion, and in some instances, as discussed, can collect data from sources autonomously or without restriction. In the example of auto truck, this is the data it collects from its surroundings as it drives on the street. Maybe you're able to attempt to limit personal information or specific information in there, such as license plates, but you still may be capturing data as well. So understanding what is defined as personal information and what isn't is absolutely critical to be able to comply. Now, one of the big concerns with privacy laws is they're jurisdiction specific. So there are some comparisons between the GDPR, Canada's PIPEDA, and in the US the legislation there, but there are significant differences between them too as well. And the way privacy laws throughout these jurisdictions usually relate to is the residence of the individual to which the personal information relates. So with that in mind, having an understanding of the individual's residency and then what laws really apply to that. Now, if we're talking about hundreds of thousands of people or thousands of people, it can be hard to parse out. So you really have to be aware of the data set you're using or the collection methods used as well. Now, being cognizant not only of where the residency is, but also restrictions on use is absolutely critical. And then ensuring that you have consent from third parties to use their information is a must. When you're also thinking about this, think about the sensitivity of data. In most jurisdictions, the more sensitive information is, the more restrictive your use will be too as well. So that's an absolute critical piece. And as well as finding out where your data is from. So if you're using third-party providers to provide sources of data, ensure that your agreements with them have terms that require them to gain consent from users, not for just the purposes for which they've used it, but for the purposes for which you as their customer intend to use it. That is absolutely critical because it all flows down. So being aware of privacy law that apply is absolutely critical, and data protection laws is absolutely critical, and just ensuring that you can navigate these appropriately. So best practices when looking at these privacy restrictions is understand first what data sources you intend to utilize. Constructing a data flow diagram is extremely helpful in this instance, where you can see where data is coming from, how it will be used, who will use it, who will access it, and for what purposes it is used. Understanding your compliance obligations then under all applicable privacy laws is the next step here. So seeing what you have to do with what you have, and then ensuring that the AI system that you've developed complies with those laws. We always go back to the concept of privacy by design. This is an absolutely critical point here, where you take in consideration when building and constructing the solution and developing it, what laws apply, whether it be under the GDPR's right to be forgotten. How do you implement that technically? Getting that in early avoids you having to go back and fixing it after the fact. So then from there, ensuring that once you know what laws apply, ensuring that you have mechanisms in there to allow for consent from individuals or confirmation of consent from your third-party sources. Obviously, practicing caution when contracting these outsourcing business functions, such as bringing data in from third parties. It's critical to, one, provide and perform due diligence on the companies, but two, ensuring that they have met their obligations so you're not offside these laws as well. Okay, so I know there was a lot of information to take in there, but and this was a bit of a brief overview of these to give you a bit of an understanding of some of the concerns that are facing AI systems from the legal side. There are many others too as well, but these are some of the bigger ones that are really developing and need to be addressed now. Some of the key takeaways from this session really are that ensuring that your contracts contemplate the nuances of AI. So ensuring that from an ownership perspective, that you have the rights to it, ensuring from a liability perspective, you're covered and the right person, whether it be customer, supplier, or a third party, is on the hook for that liability. And ensuring that your company can continue if a claim does come up. And to that point, it's really ensuring that all stakeholders are aware of it. So not just having it in the contract, but also having that frank discussion with your customers to explain to them the parameters and restrictions of use. And I think really doing that up front, from my experience, has really reduced negotiations and cycles when it comes to negotiations, because once everyone's on the same page initially, you get that comfort and understanding. Also, looking to limit your liability to avoid that bet the company litigation is critical. We do that through the contract and then through insurance. And then from the privacy side, understanding what privacy laws apply and how to comply with these data protection laws. The same conversation happens if you're operating in a highly regulated industry. Understanding what specific laws apply to that industry is absolutely critical too, just to ensure your compliance. And really, there's a lot to take in here and a lot of issues here, and it's really understanding what laws apply and ensuring you engage appropriate advisors to advise your business. Anyway, that's been the points I wanted to discuss today. Thanks for joining me here today. It's I know we're in an unusual setting here, but I hope it was useful. And if you have any questions, please feel free to reach out.